Thank you very much for coming. What I'm going to do is talk a little bit about intellectual property. Before that, I was asked to say a little bit about my background, how I got to where I am, and so I have a slide just telling you a little bit about my career path. There have been challenges along the way on that path, and for me personally, I've always looked to my parents for my experiences, because when there have been difficulties, I always look at the fact that they came here in the 1950s, that they had to go through a lot to try to get me educated. And whenever I face challenges in my career, I've looked at them and I thought they had to endure a lot more than I did. So one of the bits of advice that I was going to give individually, but I thought I may as well say it now, is that when you have any difficulties, always think about the people who helped you get you where you are now, and typically it's your parents, and that the sacrifices that they had to make to get you there. So enough of that. I'll just tell you a little bit about how I got to where I am. I'm an intellectual property lawyer. I didn't start out wanting to do that. I wanted to become an engineer. I was very interested in physics. And so my early education was to do with electronics, computer science, where I went to the University of Wales. And then after that, I did a PhD in medical electronics. And I tried to get a job in medical electronics, but all the jobs at that time in the early 90s were in the States. And I didn't really want to go to California because I wanted to stay in London. So I looked around, and most of the jobs at that time were to do with military electronics, building weapons systems and defense, this, that, and the other. So again, I wasn't very keen on that. And so I stumbled across, in the careers library, this profession, which is the patent profession, intellectual property. And what that really entails is trying to get people from an engineering or science background and to train them in the law so that they can apply the law to the latest technology, to try to protect that technology, to try to help that technology be able to be commercialized, and give reward to the inventors who created it. Intellectual property covers a vast area of things, which I'll talk about shortly, but in my career, that was the patent profession that I went through. It was, at the time, it was a very white-dominated Anglo-Saxon profession. I think I was the first Asian attorney in Europe, in fact. So it was very, very challenging at that time. And there was quite a lot of racism about as well. But hopefully nowadays it's not as acute as it was then. Even after finishing my PhD, I had to do professional exams. And I took exams until the age of 31. So, every year taking exams to become a European patent attorney and to become a chartered patent attorney. So 5 years of learning and doing exams following my PhD. It's very much similar to accountancy, where you do exams on the job to become a chartered accountant. At the end of that process, I was qualified, and I was getting quite frustrated at my company, which was a large company. I was a small cog in quite a large machine, if you like. And at that time, I decided to change my company, and I moved to what was then called David Keltie Associates, but now it's called Keltie, to create something new. I took a big risk at that time, and that's part of, I think, anybody's journey, that you have to sometimes take a step into something which looks risky on paper, but you have to kind of follow your gut instinct and think, well, actually, I think this is the right thing to do. So I joined effectively a startup. They were only 9 years old in a profession that's 250 years old. So I joined. I remember I was still answering the phones because we only had 10 people in the company. But since that time, then I qualified as a chartered engineer, and I became a partner in the company. We drove this very small company to do lots of challenging but kind of like different things. In a very old profession, we tried to win awards and try to do something quite different. As a result of that, we won the Queen's Award for Enterprise. We were ranked for 2 years in a row 16th in the UK as one of the best small companies to work in. And more recently, we've been in the top 10 firms in Europe for patents. So you can have that influence in a small company as you're growing it, but you have to try to distinguish yourself, and that's kind of what we've been trying to do. So that's really my journey as it is right now. And I'm still at Keltie, and recently I've just been made managing partner of the firm, so we will try to... There's a call coming in, so shall I just okay, all right. So now I'm going to tell you a little bit about intellectual property. And what is intellectual property? It's essentially different kinds of rights that help to protect innovation or ideas or brands. And there are two different types, as I'll show you on this next slide. There are the ones that you'll all very much like, the unregistered IP rights, because they're free, they're automatic, you don't have to pay for them. They come into being when something is created. So you will all have heard of copyright, I'm sure. That's the C with a circle. That's when something is original, is created, it's written down, it's recorded in some substance. And copyright's very useful for really protecting you against mass copying. So when you have a photograph or you have a picture that people will want to faithfully reproduce all the time, copyright's really great, because so long as you've recorded when you have created that right, you can have a right for the life of the author plus 70 years. So it's really, really very good. Similarly with design right, if you create a new kind of object or a shape or a configuration, you can get some automatic rights. However, those rights are very limited for design rights because the registered rights actually trump them, and I'll talk about those in a second. The other thing which is increasing is trade secrets. So trade secrets are particularly applicable to things which, if you put them in the marketplace, somebody will not be able to reverse engineer it. So an example of that is Coca-Cola. The formula for Coca-Cola was not known for 70 years because nobody could reverse engineer it. And so Coca-Cola did not file patents for their formula. And similarly, you see that with AI now. For example, a lot of the technology in AI is to do with how you train the large language model. And you can't necessarily reverse engineer that from use of the AI. So we don't know, sitting here, how a ChatGPT has been trained specifically to do what it does. That's a trade secret. So there are trademarks as well, and that will probably be the most common IP right that you come across, because it's to do with brands, it's to do with your brand of origin. Where do these goods and services come from? So if you're trying to establish your brand as something which people recognize, I mean, Samsung was mentioned earlier, and Apple was mentioned earlier, and people, when they see an Apple product, they associate a particular quality, a particular style with that brand. And that's what trademarks and service marks do. They give you that kind of branding. As an unregistered right, you are relying upon common law to enforce that. So you have to prove that when somebody sees your mark, that they think of you, not somebody else. And that's quite a hard thing to do. You have to go to court to prove that. But you do have those rights as a last resort. And whenever you see the word TM or SM, those are referring to unregistered rights. They are automatic. The area where I work in more is the registered rights, something you actually have to pay for. But essentially, they break down into kind of three areas. Patents, which is what I'm involved in, which is really the legal protection for your technological ideas. Anything to do with technology, and technology is very broad, so from chemistry, mechanical engineering, biotech, software, all of these areas are covered. But if you have something which is a technical idea, you can protect it for up to 20 years. And I'll talk a little bit more about that in a second. Trademarks, as I mentioned, is a sign, a word, a logo, which people can associate with you. And there are certain tests you need to go through to get that registered, which I'll also mention. And a design, which is really the protection of the way in which you've expressed an idea. It's to do with the very specific way. So if you have a website and the functionality of the website, two websites is going to be very similar, but one's going to look very different to another. It's the way it looks that you can protect, and that's what a design does. So, moving on to registered trademarks and registered service marks. So a trademark can cover a company, it can cover goods. A service mark covers the services that you would provide from that. Now, the great advantage of this registered right is you do not have to prove that you have a reputation in the industry to enforce your rights. You just simply have a registration, and that's good enough to do that. The registration relates to goods and services, and there are 42 classes. And when you file a trademark, you have to say which classes your trademark is to be applied in, and then specifically what kind of goods within that class. And your protection is for what you have specified. So if I register, I don't know, flour for a computer, I can't then use that trademark against somebody who's using the word flour for, I don't know, a microphone. It's very specific to the goods and services that you have specified. A trademark can last forever. Some of them are over 150 years old. They renew every 10 years. So it's something which is quite useful as your company grows. And you can actually get a single trademark that covers the whole of the EU, which is quite economical. The kinds of tests that they're going to do for a trademark is the trademark distinctive? When people look at that, do they think, oh, okay, that's something to do with a company? So if you try to protect a word, let's say, for example, I said, I want to protect the word laptop for computers. The registry is not going to allow that because everybody in the field of computers wants to use the word laptop to describe what they're doing. So you're not going to get, it's got to be distinctive, the word. Can it distinguish your goods and services? It's got to be non-descriptive. So you can't talk about the things which, the function or the origin or the quality of the word. So I've given an example here, Pakistani mangoes. If I tried to apply for a trademark, that would be refused because the word Pakistani gives me the origin of where those mangoes came from. And that's something which you're not allowed to do. However, example here is elephant atta. The word atta is descriptive of what the chapati flour is. However, the word elephant isn't. Elephant's got nothing to do with that. So in combination, elephant atta will be something that is protectable. Obviously, if somebody has registered the trademark before, then it's not going to be original, or if someone's using the trademark, obviously your idea has to be original, and it has to be something which is not misleading. So the example I've given there is if you have a trademark pure Swiss for chocolates, but actually they don't come from Switzerland at all. So that's kind of misleading, because if I picked up a bar of chocolate and said pure Swiss, I would think, oh, that comes from Switzerland. So these are the kind of tests that they apply. And you can apply for trademarks, or you can rely on your common law rights. The only piece of advice I would give you is if you are launching a product or you're coming out into the market, spend some time or money using a trademark attorney to do a search before you launch your product. There are many cases where people don't do the search. They file under a particular brand, and then the next thing they receive is a letter to stop what they're doing because somebody else owns those rights. And the cost of rebranding is significant, can be significant, compared to doing a search and just saying, well, we can't use that brand. Okay, so patents. What are patents? Patents are something which protects your idea, your technical idea, and governments don't like giving monopolies, but they give you a monopoly for a patent if you give them something back in return. And what they want from you is disclosure. They want to understand what it is that you're doing. So you have to disclose what your invention is in a patent application, and then if you pass their tests, you'll be given this monopoly. Now that disclosure is of how your invention works. One example of how your invention works, and it remains secret for 18 months, and then it gets published for the world to see. So you can understand now the balance between a trade secret and a patent, because a patent is going to disclose what you're doing. You've got to be comfortable with that before you come to a patent. 20-year term, as I mentioned, and it typically takes 3 to 4 years to get a patent granted. You can accelerate that in certain cases, but typically it's 3 to 4 years. They are territorial rights, so you have to get a patent for the UK, a patent for America, a patent for Pakistan, a patent for whichever country you're interested in. There are certain countries which allow you to group those countries together, like Europe, but ultimately, enforceability-wise, it's on a country-by-country basis. You don't have to file in all these countries at the beginning. You can file in one country, and then you have 12 months to file in other countries of the world. But they are the most expensive IP right. Drafting a patent application, 10 to 15,000 pounds, depending on the technology. And then there are going to be charges and costs for getting it granted and prosecuting it. So it is not cheap, but it can be very vital, and it's kind of quite important to think about that. One of the statistics I was just going to mention, which I should have mentioned at the beginning, is that there was a survey done in 1975 of companies all around the world and how many intangible assets they had. And it was about 17% of companies' assets were intangible. In other words, they weren't, they're more intellectual, or they were brands, or they were patents, or they were know-how. That's really spiked up, and in the last year, it was about 90% of the assets of most companies are intangible, which makes it a nightmare for accountants, because how do you value IP? It's very, very difficult to do that. But it is an area which is very important. You should be thinking about it, because most companies, and it maybe feeds into business plans as well, what is it that you've got that gives value to a company? And investors do look at patents, trademarks, these kinds of things. So why have a patent? It's got to be a commercial decision. The days of having inventors who just invent for fun are long gone. It's got to be commercial. It's got to do with what your company is trying to achieve. Everybody thinks patents are just about protecting your ideas, but that's not the number one reason people file patents. The number one reason is to really provide assets to the company, provide some defensive positioning. Just having patent pending can put people off. It can have a deterrent effect. It also gives you a marketing opportunity as well, because there are companies like L'Oreal and Dyson that make a huge play on the fact that they are innovative companies, and the patent is a badge of innovation. There are licensing opportunities. You don't even have to exploit that technology. You can license it to third parties. And the number one thing in the financial markets, or financial fintech clients that I've got, is that it can give you tax benefits. So corporation tax is at 25% for the profits of companies. If you have a patent that relates to what you're doing, you can put the profits into something called patent box and be charged at 10% corporation tax. That's the number one driver for insurance companies, banks, hedge funds coming to me to say, please find me something that I can patent because I want to save tax. So it's worthwhile bearing that in mind. So, and the last slide I'm going to just talk about is, so we've talked about what is a patent, why you might want it. There are 3 tests that you are put to, but the government puts you to say, can I get a patent for this idea? The first is called novelty. Is your idea in the public domain? So whatever it is you want to protect, is the concept that you've had, is it in the public domain? So that will be a check that they do for everything that they can find that's been patented. They'll do Google searches. They'll look at research papers from universities, anything that's been published. But also remember, if you speak to an investor and you haven't got that investor signed with an NDA, or if they refuse to do it, then that could be a disclosure, which is your own publication, which can act against you. So the number one thing to remember is to make sure you disclose your idea in confidence, confidentiality agreement, or you make absolutely clear in written correspondence, this is a confidential idea and you are not free to go and tell other people about it. So let's assume that that's the first test and you're clear that nobody has come up with this idea before. The second test that the Patent Office do is called inventive step. And what they're looking for is saying, how clever is your idea compared to what was done before? But that's a very subjective issue as to how clever something is. A university professor will tell you this is not very clever at all, whereas a university graduate will say that's amazing. So the way that the Patent Office looks at it is that they see, okay, let's identify the difference between what you do and what's been done before, and can you associate advantages to that difference? So to give you an example, many of you may play squash. I know that Jahangir Saab has a very famous squash player who he shares the name with. But squash was invented 150 years ago. People played with a green-coloured squash ball and a black-coloured squash ball. In the 1960s, a British guy came up with the idea of a blue-coloured squash ball, and he applied for a patent for it. And so the Patent Office did their tests. They said, okay, is this new? Has anyone seen a blue squash ball before? No, no one's seen a blue squash ball. So it passes the novelty test. But surely it fails on inventive step. That's not clever, having a blue squash ball. I can have yellow with pink spots on it. Why should I give you a monopoly for a blue-coloured squash ball? But the inventor said, no, actually, blue, I've realized, is a short wavelength. And as you see the ball flying around the court, you can see it a fraction of a second quicker because it's a short wavelength. And the Patent Office said, no, that's still not allowable. And he took it to court. He went to the Court of Appeal, and they said, no, that's absolutely right. The advantage is associated with the difference. So he got a monopoly to blue-coloured squash balls. So it may seem trivial, but remember that it's comparing to what's out there. Is there an advantage, technical advantage to what you have created? That's the difference. And the last step is that there's a category of things which are not permitted to be protected, but they are very narrow. So a computer for a program for a computer, a method of doing business. These are kind of, a method of playing a game, but these are very, very narrow. So all you have to show is that you've solved a technical problem. So if you can show that, then you can overcome this third step. And that's really kind of like an introduction to patents and to the technology. I'm happy to take questions on anything that I've talked about or anything else.
Is working? Yeah.
Yeah.
Thank you. About trademarks.
Yeah.
So when I advise to my client, or I also act in the same way, okay, you need this name for your business, get it registered at company's house, get a website. Is that enough? Or do we still need to go beyond?
Well, as I said, the one piece of advice I would have is do some background searching. Company's house, yes. The URL for the website, very good. But trademarks can protect. Someone can file a trademark and they may not have the URL, they may not have the company's house registration, but they have the trademark. Now, if they have a trademark, they can stop you. They can stop you from launching your product. The last thing you want is a letter before action, because when they send you that, they will say, right, you have damaged our reputation, we want you. So what I would recommend is doing searches, trademark searches. And trademarks are territorial rights. So you could do something yourself. You could have a look on the trademark register, which is available free of charge, and see what marks are similar to yours. And then, as I said, you have to compare the goods and services that those trademarks relate to. And if you do that, you can get an idea, but often there's some kind of overlap. And I think trademark searching isn't that expensive, maybe £1,000, £1,500 for a keyword search in the UK, and that would give you peace of mind. It would also be something you could feed into a business plan to say, we've also carried out searches, and you give the investor a bit of confidence that if he launches this product, he's not going to have to pay for trying to get you out of that problem. So it's a little bit of due diligence, if you like, and it's not too expensive, but it gives you some comfort, and I would recommend you do that.
Assalamualaikum. Shakeel Ahmad, very, very interesting. I have probably two questions. One is to ask you, regarding your career, what particular patent have you been involved in that now you see the fruits of in real life? That's, you know, that you've been involved in from the beginning and come to fruition and something that we may know in our daily life and stuff. So that's one of the first questions. The second one was related to the idea of, you mentioned about insurance companies coming to you regarding obtaining that sort of 10% corporate tax rate or whatever it is. Just want to understand that. Does that mean that they're looking for patents within their own profession, or they're willing to invest in another kind of patent in order to do that? So I was just trying to understand that part better.
Okay. So I'll take your first question. I drafted a patent for a company called Travel Fusion. I think it was probably 30 years, 25 years ago. And they came up with the idea of you have one type of transport, and then you have another type of transport and a third type of transport to get you from A to B, linking up together different types of transport. They sold that patent to TfL. So the TfL planner you have now was the original, it's expired now, but the original patent was something I drafted to multimodal travel. So getting from A to B, previously you say, well, how do I get from A to B? And you say, well, find the nearest train station to go from A to B. And these guys came up with, well, we can do bits of journey from different types of transport, and we connect them all together, and we can then find out the fastest way to get from A to B. And that's multimodal travel planning, and the company was Travel Fusion, and they sold their patent to TfL, or TfL took a license from it. They sold it to Google, in fact, and TfL took a license from it. So that's an example where patents can help, and that was a small startup company, and they did very well out of it. So, and sorry, your second question, I forgot. Right, oh yes, patent box. So the insurance companies or the hedge funds, they look for technology that they are using rather than what somebody else is using. They have to come up with something that's patentable in what they do. So pretty much all financial tech companies or financial companies have some platform, or they have some processes that go on that platform. All I have to do is I have to find a tiny part of that platform that is clever, that's inventive. And then they get the benefit from all of the revenue that comes and touches that platform. It's very, very underutilized, and it's something which is very advantageous to companies. But obviously you have to be generating a profit. So there's a balance between startups who are going to have to go through various phases to get to that profit, and companies that are generating profit. Companies that are generating profit, they are looking for ways to reduce tax, and a patent now is becoming a very, very popular way of reducing tax. We just have to find something that's innovative in everything that they do, file a patent for that, get the patent granted, and then they qualify for this. And the benefits aren't just for the UK. So if you have a UK company that has a UK patent, but they are getting revenue from all over the world, and it's coming into the UK, they can be taxed at 10% rather than 25%. So it's very generous. I'm not an accountant, but you know, it's something which accountant firms come to me and they talk to me about how can we get this for our clients. So.
Assalamu alaikum. Actually, last week I filed one patent for my one invention. Oh. So there are some part related to the AI, like LLM, large learning module and everything. Do we need to register for trade secret, or only just we can keep on patent?
I suppose the question you have to ask yourself is, when my product or my service goes out to the market, will someone be able to reverse engineer and do what I'm doing eventually? If they will, then it's probably fine to apply for a patent. You still have this 18 months before it gets published.
So once we submitted, the day itself you will get the protection, or it will take 18 months?
So the day you file a patent application is the day on which you start to accrue the benefits of Patent Box, but also it's where you stop other people's disclosures and your own disclosures counting against you. So it's, if you like, you put a flag in the ground saying, this is the date of my invention. It's going to take you some time to get that patent granted. Only when it's granted can you enforce it against other people. The publication date is important because when your application publishes, then a meter starts running for damages. So if I was your competitor and I saw, after 18 months, I saw your idea and I copied it and I copied the idea and I started using it, eventually when you get your patent, you can go to them and say, you took my idea and I want damages going back to the date when my application published, because that's when you knew about it, or that's when the world knew about it. So publication is important for that. But if you feel that they will not be able to eventually train a large language model to do what you're doing, then maybe a trade secret is better. It really depends. You will definitely have lead time to market because the amount of time you've spent in training that LLM is going to give you an advantage. Even if someone sees your idea on the market, they're still going to have to train their LLM to do what you're doing. However, if they will eventually get there, then a patent is probably the better thing to do. It also helps you, as I said, for investment, for tax, for various other reasons.
So this protection only for this UK itself or all over the world? How we can, because maybe...
Yeah, so protection is done country by country, on a country by country basis. If you filed your patent application, you have 12 months to file in other countries. Okay. You have to look at your markets. Where are your markets going to be? Or where are the markets going to be that you could license the technology to somebody else? And you have to lock down those markets. Having a patent can increase the amount of license revenue you get. You can ask for a higher percentage to license your technology because you have a patent. Because what the licensee is getting is they're not only getting the technology from you, the idea, how it works, the know-how, they're also getting this umbrella protection, which means that their market is also protected to some degree by the patent. So it does generate higher revenues if you have a patent.
We have another question at the back, but quickly asking you, is it the publication date of patent or the acceptance date that's relevant? You just mentioned in your example.
So the publication date doesn't give you any rights except for back damages. So only when you get a patent granted is it a right that you can use to stop people doing various things.
Assalamu alaikum. Question is with regards to defense of patents. So a patent is granted, you may face some issue with trademark and some infringement. Is there a statute of limitation in terms of how long you can apply for damages, etc., for the patent, in case, for example, as a small business, you don't have the funds to defend your IP at that particular moment, but you wish to do so at a later stage?
Yeah, the statute of limitations is a 6-year rule which stops you from exercising your rights against something which happened over 6 years ago. That is very relevant for damages. So the day you enforce your patent, you can only go back 6 years for damages. But you can enforce your patent at any time during it. Even if you've known about the infringement, but you haven't had there's funds to exercise against that, that is a legitimate reason to bring an action a bit later. The other side will try to argue that you should have brought it earlier, but it is a defense to that argument to say we just did not have the funds to do it, or we were trying to get the funds together to try to stop this. We were looking for partners who would support our efforts to try to stop this infringement. Different countries have slightly different rules. So I think in the US it's slightly different, but I'd have to look into that in more detail. But there are slightly different rules and different. But in the UK, you can bring an action if you have a patent that's granted. The only thing about a UK patent is that if you're in the last 4 years of the patent, then the person that you're suing, and if you're trying to sue them to stop them doing what they're doing, they can apply for something called a compulsory license. In other words, they say, you can't stop us doing it, but we will pay you a license because you're in the last 4 years of this 20-year term. So they can do that as a defense, but you will still get licensing fees out of it.
Jazakallah. One thing that really amazes me about this Jamaat is in every field of human endeavor, we have experts by the grace of Allah. I'm really fascinated to know that we have such an expert in this unique area of human achievement. So Jazakallah for that. I guess I got two questions. One more personal. Feel free to sidestep it or take it offline if you want to. But this area of intellectual property has always intrigued me. Say, for instance, I work for a firm or business. While I'm there, I develop some software system to streamline the operations. I know we sign all these disclaimers before we join as independent or permanent employee, but how much right do I have to that intellectual property if and when I leave the firm, if I want to take that with me?
Okay,
that's one question.
So as an employee, most contracts, as you quite rightly say, they say that if you create an invention in the course of your employment and that the employment, it's your role to come up with ideas or work on these ideas, then typically the rights belong to the employer. There's not much you can do about that. However, if what you come up with is something which is not expected of your job. So let's say you're in marketing and you come up with a brilliant engineering idea. You're not an engineer, you're not paid to do research and development. It's not expected that you'll come up with ideas. You would have even if you've signed an agreement, you would have a cause to say, well, hold on, this is not my job, and I've come up with something independently, so I should have the rights, or I should get some benefit from this. You have that right. The other thing is that if you are someone who's come up with something, regardless of whether or not it's in the course of your employment, and it's what you've been expected to do, you have a moral right to be named as an inventor on any patent. If you are not named as an inventor and you did have a contribution, that's something that you can again use to maybe convince the company that you need to get some recompensation for excluding you as an inventor because you have a moral right to be named.
Jazakallah for that. I guess my second question, probably more generic for us here, for today's event. And you mentioned about the concept of registered and unregistered. How would you advise somebody? When do you make that decision to become registered? How do you navigate that? Because obviously registration costs has some significant cost to it. So as a small business entrepreneur, what would your advice be to navigate that path between registered and unregistered?
I think if you don't have the funds to do it properly, then, and I know some people have done this already, you can file it yourself. It's not very complicated in terms of you have a mark and you have, or a slogan or a logo, you can file for it, you can designate the classes. The only thing that I would say is that if you file a trademark and you do that and you get the advantages of it, as soon as you do have the funds and your business takes off, go and speak to a professional about it, because that mark may not actually cover what you think it covers. And it may be restricted, overly restricted to what you think it is. The other thing is, if you file your own trademark, you simply have to pay the registration fees, which are not huge, but you may get some objections along the lines that I mentioned. And when you get those kinds of objections, you really ought to take, again, professional advice, because it could mean that the money you've spent is going to be worthless if you make amendments that are not really going to serve the commercial purposes. So you already have the automatic rights, and to act as a deterrent effect, I would put, if I can just probably get them back up on this screen. Yeah, so I would, whenever you create something, these three circles at the top here, copyright, TM in a circle, or SM in a circle, put that on your literature, on your marketing materials. It's free. It's just telling people that you're using a word as a trademark. If you use a particular word as a trademark that doesn't pass the tests, but you use it for a long enough period of time, and it becomes so well known to people that they know what the origin is by looking at it, then it can become registrable as a result of that. So an example is American Airlines. American Airlines, that would not pass the test that I said, because it's telling you that the airlines are from America. So it's telling you about the origin, a bit like Pakistani mangoes. But because they've used American Airlines for 70, 80 years, it's become distinctive of that brand, of that company. And so if they can show to the registry, look, we have all this evidence to show when we say American Airlines, they think of our company. They don't think of all the other American airlines, they think of only our company. Then that can be evidence to get you the registration. And that's exactly what they did. And there are many other examples of that. So you can start off using these logos and tell people that you understand intellectual property. Put it into your business plans, because an investor will think, oh, you've thought about intellectual property. That's good. That gives me some little bit of you are showing that you're knowledgeable in trying to protect the rights that I will want eventually to protect my investment. But when you can, then you can't put R in a circle until you file a registered and get it registered a trademark. So that's what I would try to do.
Jazakallah.
Thank you.
There's one more question.
Cool. So yes.
Oh, yes, one more there.
Assalamualaikum. Yeah, I just have a question regarding trademarks. If you have a registered trademark and then someone goes to Companies House and registers a company on the same name, is there any legal protection for that? Or?
So registering a name per se doesn't constitute an infringement of a registered trademark. It's when they start using that name in commerce that it becomes an issue which a registered trademark can be applied against. The thing is that, like I said, the trademark that you've got registered is very specific for the class of goods and the type of goods or services. And you have to map the activity that that company is doing to what you've written down in your trademark as in terms of the goods and services. So, for example, elephant atta was the example that I used. If I try to sell any food-related products, which may be similar to elephant atta, then they might be able to stop me because they say, well, elephant atta is so well known that our trademark, our goods and services cover other foodstuffs. But if you use that logo or that name for something which is completely unrelated, then they can't use that trademark against you. And similarly, if you're trying to enforce your trademark against a company, it's the activity that they're doing that's the most important thing. If that activity falls within the classes that you've specified, then you can send them a letter before action, say stop what you're doing, and pay me compensation. There's all kinds of things you can do. Yeah. Sorry, there was one more question.
Yeah, just a quick question. So if someone's looking to get a patent, let's say in another country, let's say more broadly speaking, let's say the Middle East or Africa, what are the potential challenges or risks that someone can actually face over there?
So the courts in many of those countries are not so well developed. So it can be a bit more challenging to enforce your rights. But having said that, that usually applies to multinationals because they know the law, they know the remedies. If it's a small local company and you have IP rights, the mere fact that you have IP rights is quite often to say that I'm sorry, we didn't know, and they'll stop doing what they're doing. China's a good example of that. For example, 20 years ago, everybody was copying everything in China, and it was very difficult to enforce intellectual property rights. But now they have a much more sophisticated system, and you can enforce those rights there. And people are very wary of the fact you have a government piece of paper with a red stamp on it which says, I have a patent. And if you don't comply with what a court's saying, you're going to be probably thrown into jail. No, I'm just going to stop doing what I'm doing. In places like Africa, it's very underdeveloped. So you can apply for patents, you can get patents. Enforcing them is probably very difficult, but I think they have a much bigger deterrent effect because people don't understand patents. So I think they will be much more wary. And if you say you have a patent in that country, they are more likely to say, okay, fine, we didn't know, we'll stop doing what we're doing, which has the effect that you want.
Exactly.
Okay, thank you. Sorry, I'm conscious I've taken up a lot of time.
So, shall we close?
Yeah,
Yeah.
thank you. Thank you very much.